Welcome everyone to today's webinar, Workplace Safety Committees under the New York State HERO Act, presented by Barclay Damon. Many thanks to our presenter, Michael Schiatti, for being here with us today, to all the participants who have joined in, and to our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. All attendees will receive the link to the recording. Michael will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Michael to start things off.
Great, thank you. Good morning, everyone. Today we're going to talk about the Workplace Safety Committees under the HERO Act, and this is not COVID. This is a permanent law that is going to survive whether COVID ends, doesn't end, whatever the case may be, and you need to be aware of this. The HERO Act primary, which we went over last year, was basically, a written plan that you had to put in place should the state of New York activate an airborne disease, which they did on COVID-19. And as a result of that, you had to comply in that regard. So when they released the HERO Act, they said, yeah, there's going to be these rules coming out on the Workplace Safety Committee, because there was a lot of unanswered questions, as you're going to see. And they finally released proposed regs, and I don't think there will be too many changes. So the proposed regs are out. We're going to go through those. I will warn you, there's parts of this presentation, especially when we get into the definition part, it's very specific and you really have to pay attention. And at the same extent, it's really boring and there's not a lot of a way to juice it up. But I'll sort of warn you when we hit that part. I still don't think we have all the answers, but we're in a better position now in that regard. I put my contact information up here. Should you think of a follow-up question you might have not thought of today, I'm happy to answer general follow-up questions. I am on Twitter and LinkedIn. It's a good way to stay up to date on labor and employment and other legal developments. So for the joint Workplace Safety Committee, we have the underlying law, and all we have is right now is proposed regulations. We're going to walk you through those proposed regulations. If you comply with proposed regulations, you are in compliance with the law. At some point later this spring or early summer, they will finalize the regulations. There might be some tweaks, but generally speaking, what I'm about to go over is going to be very close to what New York State finally puts in place. The Workplace Safety Committees, I gave you the legal citation here, and the Workplace Safety Committees went into effect on November 1 of last year in 2021. But we didn't know a lot. So now we have these proposed regs, and I'm going to walk you through this other detail here. Who's a covered employee? Who's a covered employer? It's different than the HERO Act primary, just so you're aware. We'll go through the definition section, and that is the one that I'll warn you ahead of time. It's pretty boring, and I try to move through it quickly, and you can go back and analyze where you fall in that regard. They put in place establishment rules, how to establish a Workplace Safety Committee, what is necessary. There was some discussion initially. Did the employer had to initiate it, or did the employees have to initiate it? I reasoned it was an employee initiated. It turned out I was correct, and I'll walk you through that. So you don't have to just establish a Workplace Safety Committee. You can if you want. You're only required to when we go under these establishment rules and what have you. There's a lot of questions as to, did the committee have to be 3 people, 6 people? The language I could have interpreted either way. We now have an answer to that, and I'll walk you through how the committee has to be constituted at a minimum. They also put in place some governance rules, how the committee is going to operate. just so you're aware, it's pretty much can be the wild, wild west in that regard. You as an employer have certain obligations, real simple, don't interfere. They want to form the workplace safety committee. The employee that you hate the most turns out to be on the committee. Oh, well, not much we're going to be able to do about it. And then lastly, we'll go over what legal claims can be made by an employee against the employer as a result of the workplace safety committees and employer violations of basically the obligation section. So covered employees and employers, again, single most important question that exists out there. As I already mentioned, the statute had a bunch of unanswered questions, and we were looking forward to getting these rules. So the statute basically defined an employee as all employees within the state of New York, except those employed by the government. In the regulation, the definition remains the same, no surprise there. Basically, we're dealing with a private sector employee, not a public sector employee. The statute defined an employer as any type of business within the state that has at least 10 employees. Doesn't matter if it's a corporation, partnership, sole proprietorship, etc. The regulation continued that part, that at least 10, and the employer has to be a private sector employer, not a public sector employer. One of the questions that was begged under the statute is, how do we count the employees? And when do we count the employees? They've answered that for us. The number of employees to determine whether, and let me just put this in perspective. If you have 100 employees, you're covered. If your workforce fluctuates between 8, 9, 10, 12, that's really where you got to pay attention here. Or if your workforce now is maybe at 5 and you think you're going to jump to 20, that's where I think you need to pay attention. It's going to be determined by counting the total number of employees employed within the state of New York. So we would take the aggregate amount, whether they're different workplaces or not, we total them up. We will count the following. You will count employees on paid or unpaid leave. You will count employees based on sick leave that are out on sick leave, a leave of absence, a disciplinary suspension, or any other type of temporary absence, as long as there is a reasonable expectation that they will return to active employment. And that is really for you as the employer to make that determination, and it can change. I mean, yeah, we intend to bring Tommy back at the end of his FEMLA leave. You do that when you're counting employees, and then the 12 weeks expire, he goes silent on you, and you wind up terminating him later on. If there is no employment relationship, meaning you fired him, or whether you call it a layoff and you rehire in the spring, that person is not counted because the employer-employee relationship has in fact ended. Will I count part-time employees, temporary employees, newly hired and seasonal employees? Of course, they are. If the person is an employee, they will be counted. You will not count independent contractors. Please remember, both the government and the independent contractor always have the right to challenge their status that they are really an independent contractor. If you're in a joint employment situation where the employee is working for multiple entities, even if he's only paid by one of those entities, we will count that person, shall be counted on, how would I describe it? Each employer's payroll, whether or not they actually appear. So pay attention to the joint employment situation. That may be one you have to spend a little time with to figure out, is it a joint employment situation? And then if it is, you have to count them on both companies. Okay, the definitions. I'll warn you a little bit here. This is the boring part. I'll try to go through. Once you've heard this, it's really on you to go back and figure out where you sort of fall into this. I try to, those of you who heard me speak, I try not to bore anyone during these presentations because there's nothing worse than a boring presentation. But this drives a lot of stuff. That's why I want to go through it. The statute has a definition of geographically distinct work sites. It basically means 2 or more work sites operated by the same employer that are not a single work site. And a good example of that is I got an office here in Elmira. I have an office in Albany. So those will be geographically distinct. There's some discussion, the composition of the committee. We have to have both what I call employer representatives and non-supervisory employee representatives. They have defined the term non-supervisory employee. Nothing radical here. Means any employee who does not perform supervisory responsibilities, directing control of work and performance. Now, where we get into issues is where you have that hybrid guy or girl, and are they a supervisor? Yeah, they can direct the control, but they can't fire. The firing aspect is not a requirement here. It's the direction of a control, the authority to, not maybe whether they actually do it or not. It's the authority to. Non-supervisory employee excludes managerial and executive employees. Later on in this presentation, this will make sense. The term notice is defined. I wanted to keep all the definitions together. Means a written, posted, or electronic notice to an employee that's calculated to give them some knowledge. And again, nothing radical there. Just I wanted it here in the definitions. It will make sense later on. A temporary work site means a work location at which no employees work for fewer than 20 working days. So just keep that in mind. It's a work location at which no employees work for fewer than 20 working days. A work site is also defined. It means a single physical location where services, operations, and activities are performed, provided that several work sites within a single location or building may exist if separate employers conduct activities within that building. We see. So for example, you have an office building. On the 10th floor is one employer. On the 10th floor is another employer. On the 13th floor is another employer. So that is just, that is your typical office building one. A work site can refer to a single location or group of contiguous locations in proximity to one another, even though they're not directly connected. So it could be a compound. The employer has a compound. All the employees work there, and they're in 3 different buildings. That would be considered a single work site. Separate work buildings or facilities which are not physically connected and not in proximity to one another may be considered a work site if they are reasonably geographically proximate to each other, are used by the employer for the same purpose, and share staff and equipment. So it's not a compound, but you could have a building 4 miles away or 3 miles away, 10 miles away. It's very fact specific, but the reality is, just sort of figure out what you're dealing with, and then from that will flow what your obligations are. Contiguous buildings or sites occupied by the same employer that have separate management, produce different products, different services, do not constitute a single work site. So the example here is you have an owner who has their hands in many things. In building 1, it's company X that the owner owns, and they make widgets. In company 2, it's a car dealership that the guy owns. In company 3, it's a car detailing business. Those are 3 separate work sites, even though it's the same owner, because they do all these different things and have different employees. A non-contiguous site in the same geographic area that have separate management, produce different projects or different services do not constitute a single work site. Okay, the term work site shall not include a temporary work site, which was previously defined. Again, nice and boring, those definitions, but when you have to figure out where you fall in the work site, they will become helpful to you. A little monotonous, but I think within a half hour, you could easily figure out what your rule is. Okay, so one of the first things that the new proposed regs did was establishment rules. How do we establish, and what is our obligation to establish a workplace safety committee? So covered employers will permit employees to establish and administer a safety committee, but not more than one committee per work site. So we read this language initially as well, it seems like the employee has to ask, and that turns out to be a rule, as you'll see in a second. If you already have a safety committee in effect, and they meet the requirements of what I'm going to go over, you don't have to create a new one. Some employers had to modify the roles and the duties, I should say, of their safety committees in order to comply with the rule, specifically the composition and what they did. Committees representing geographically distinct work sites may also be formed as necessary. So remember the example I gave you, site in Albany, site in Elmira. You can have a committee at each. The establishment rules that the proposed regs have rolled out. A workplace safety committee may be established for each work site. Again, we define that. Following a written request for recognition by at least 2 non-supervisory employees who are at the work site. So you need a writing, 2 supervisory employees saying we want, non-supervisory employees who want to form this committee. So that's the test. If that test is met, you have to establish this committee. Now, sometimes you have 2 individuals that make independent requests and they didn't know about it. They didn't know about the other's request. That is going to be sufficient. They meet the 2 threshold at the end of the day. Now, once you get the request, the employer shall respond to the request with reasonable promptness. So basically say, hey, we got your letter or letters. We hereby establish the Workplace Safety Committee. Request for committee recognition received after the committee has been recognized. You shall be denied and referred to the committee. Remember, 1 committee per work site. So if, let's face it, sometimes there are pockets of employees that follow each other within the workplace, and one group came forth and got the committee established, and then this other pocket of employees who doesn't like this group writes the employer a letter saying, we'd like to establish one. It will be denied and referred to the committee. Why? Because they already had in place a workplace safety committee. If you already have a committee in place, one that you just formed or one you previously formed, you're going to deny it and refer it to the committee. Again, you may have to tweak. If you've had a safety committee for years, you just may have to tweak it a little bit to comply with the law. Within 5 days of recognition by the employer shall provide notice. Remember, I told you what notice was in the definition section, to all employees at the work site of the recognition. So you send out a memo, a letter, an email blast, whatever you want to do, as long as we can basically say, yeah, all employees have an email, great. Or we post it, or we attach it as a memo to their payroll check saying this has been formed. I already alluded to this. An employer will not interfere with a selection of non-supervisory employees. It is legally not allowed. Whoever they want on it, even if it's the employee that you hate, too bad. So we had one employer said, well, we want to make it so the employee's in good standing. And they had this long definition of good standing. No, it doesn't apply. If you have a workplace safety committees because they're geographically distinct work sites, those may also be formed by non-supervisory employee, including by a non-supervisory employee who regularly works in multiple or different geographic distinct work sites. For example, a non-supervisory employee of a traveling show may form a committee to represent the geographically distinct work sites the show travels to within the state of New York. Okay, the composition of the committee. Again, the language left a little to be desired, but we now have some clarification. The Workplace Safety Committee will be comprised of not less than 2 non-supervisory employees and not less than 1 employer representative. So the minimum size of the committee is 3 in that regard. There were some people thought 3, some people thought 6 initially. I could have went either way with it, to be honest, but the minimum number is 3. 2 non-supervisory, 1 basically employer or representative. And please note, there's no requirement that the employer representative be an employee. You can have a safety consultant come in there. You can have your attorney come in there. Typically, it's going to be an employee, but so well. There's a ratio rule. The non-supervisory employees on the committee shall not be less than 2 non-supervisory and 1 employee representative at any time. So you got to keep that 2-to-1 ratio in place. Non-supervisory employees who are not unionized, they will select the representatives to basically to this committee in that regard. They can do it by self-selection, nomination of coworkers, and if they want, they can have elections. Basically, they're going to figure out how to populate it. They're going to figure out what the procedure is for the non-supervisory employees. Where there is a union in place, the rule is very clear. The collective bargaining representative will select the employee representatives in that regard, who may be any non-supervisory employee or an employee covered by the collective bargaining agreement. Well, don't they have to be a union employee, Mike? No. Please remember, some work sites have both union and non-union employees, so they could select a non-supervisory employee who is not a member of the union. The Workplace Safety Committee, there's a maximum number they want of 12 members. This includes all representatives. And please remember, 1/3 of the total number, 12 members or 1/3 of the number of the work site, whichever is fewer. And remember, you got to keep that ratio, that 2-to-1 ratio in that regard. If you have a work site, a safety committee at a work site that has fewer than 10 employees, that will have 3 members. So remember, we count the employees statewide, but if you form a workplace safety committee at a work site that is less than 10, you're going to have 3 members, 2 non-supervisory, 1 employer representative. Workplace safety committee shall be co-chaired by a non-supervisory employee and an employer representative. No non-supervisory employee may be a member of 2 different safety committees of the same employer. So, that person that was forming the safety committees can't sit on more than 1 at the end of the day. Governance rules, the committee may take action as a committee in a manner consistent with what the government says. They may take action consistent with any rules or procedures that the government they adopt. They don't have to adopt any rules. Remember, I said it's the wild, wild west. The committee then would take action by a majority vote. And remember, the non-supervisory employees are going to outnumber the employer representatives. The Workplace Safety Committee can do anything authorized by Section 27D of the labor law in that regard. Such rules and bylaws may include, but are not limited to, how to select members, the terms of the members, and training to be provided by the members. If the Safety Committee has rules that exceed what the state of New York allows under the law, the Department of Labor has called them ultra virus, which basically is a fancy word meaning illegal, and you don't need to follow them at the end of the day. The Safety Committee is authorized to do the following under the statute: raise health and safety concerns, review policies relating to occupational safety and health, review the adoption of policies in response to new health and safety laws or amendments thereto, participate in any site visit of the government to enforce health and safety standards, and review reports filed by their employer related to health and safety. Please know there you may have to redact personal identifying information out because you're dealing with non-supervisory employees in part. Another governance rule may provide official training opportunity for committee members. It's with pay. However, the training cannot exceed 4 hours in a calendar year. So the reality of the rule is the safety committees can decide they want to do this training for committee members. It's 4 hours with pay per calendar year. Meetings will be scheduled in accordance with any rules adopted by the safety committee. If there are no rules, as agreed between the chairs, both the employer chair and the non-supervisory chair. Meetings shall be scheduled at times that do not necessarily conflict with business operations. So if the head of the committee is the head of receiving and the UPS truck comes in every day at 10, the employer sort of says, no, don't schedule it at 10 because it interferes. Do it at 8, do it at 2, do it at 1. We don't care, but just don't do it from 10 to 11. Meetings may be conducted at least once per quarter for not longer than 2 hours. Time spent during meetings are work time that must be compensated. Nothing in the law restricts the Workplace Safety Committee's ability to conduct additional meetings, but they must be conducted outside of work hours and do not constitute hours worked except with the permission of the employer. The committee, through the co-chairs, will be responsible for notifying the employees of any changes in the membership of the committee. And nothing will restrict the employer's ability to prohibit the performance of committee duties during work hours, except during quarterly committee meetings. So you got to let them form, you got to let them select, you got to let them have the quarterly meeting. But if they want to have a meeting every week, the employer could say, no, you're not doing it on work time because all I'm required to do is give you that one quarterly meeting of 2 hours each quarter. Employees work on Workplace Safety Committee matters aside from the quarterly meetings may not interfere with the performance of their work responsibilities. So did you ever have someone that took something too seriously? This rule is meant to address them. It's great you're on the committee. It's great you volunteered and self-selected, but it can't interfere with your job at the end of the day. And that's basically outside the quarterly meeting and the training requirement. Some employer obligations. Once the committee has been established, you must respond in writing to each health and safety concern raised by the committee within a reasonable period of time. It's also the committee or one of its members. You must respond to requests for policies or reports that relate to Workplace Safety Committee's duties within a reasonable time. You must provide notice. Again, we defined what that was, where practical and not prohibited by law, to the Workplace Safety Committee and its members ahead of any visit to the work site by the government. There may be no notice. It could be OSHA call, and I haven't seen this, but I guess where it's prohibited by law, OSHA comes up. We're coming out to arrest your supervisor for a health and safety violation under the OSHA law. Don't tell them we're coming. Okay, I've never seen that, but I guess that may be what they're referring to. Employers are allowed to appoint an employer representative to act on the committee and to act as a co-chair. Such employer representative may be a non-supervisory employee, any officer, a managerial employee, or other representative, the attorney, the safety consultant, in that regard. You have to permit members to attend the safety committee meetings and to do their schedule training as long as it complies with the rules that I already gave you. Mentioned this already, the training and meetings that you must do is work time. If they do anything outside of that, it's on their own time, and if they do it on the weekend, it's not work time. A couple additional obligations. You can't interfere with the performance of the duties of the committee, and no employer will be required to disclose what I call personal identifying information. You may have to redact it out when you give it to the committee. If you have the pleasure of having the union, these rules are not meant to diminish any of the remedies under the collective bargaining agreement. The provisions of the workplace safety committees can be waived in a collective bargaining agreement as long as you explicitly reference this section. So if the union and the employer want to do something else, you're free to. We just got to comply with this slide. And lastly, legal claims. If you violate any of your employer obligations, you know, there is this very broad anti-retaliation provision that exists within it. You can be deemed to have civil penalties. Depending on those penalties, you're going to see in a second, are going to depend on first or second violation and where the complaint was brought. They can file a complaint with the anti-retaliation unit of the Department of Labor, or sue you straight out in New York State Supreme Court. The penalties range from $1,000 all the way up to $20,000 for second violation within 6 years. So some pretty stiff penalties. Some other things the Department of Labor can order if the complaint was filed with the Department of Labor. An injunction, they can order a payment of liquidated damages to the employee by the person or entity who caused the violation. They can order reinstatement. They can order front pay in lieu of reinstatement, and they can order back pay in that regard. Liquidated damages shall be calculated in amount not more than $20,000. The DOL may assess liquidated damages on behalf of every aggrieved employee. So it's not just a one employee. You got 10 employees affected. 10 times 20 is $200,000. So you could be looking at some pretty stiff penalties here for what is basically a harmless committee. At the end of the day, they have 2 years to sue you out and straight out in New York State Supreme Court. If they had previously filed a claim with the DOL, that stays that 2-year period. It's called tolling. If you sue, you must give notice to the New York State Department of Law, the Attorney General, and liquidated damages are mandatory in a lawsuit, but discretionary before the Department of Labor. So that is, you know, a quick and dirty what's there. I did throw a lot at you, and the devil's in the details. You know, the most important thing is find out, you know, the work site, work through that, and then you got to wait for 2 employees to come forward. And if they don't, you never have to do this. Can I self-form the committee ahead of time? Sure. That's up to you. You're not required to. And, you can simply do that if you wish. The final rules should come out within a month or so, is my guess. Maybe early summer at the latest. And if necessary, if there's a radical departure from what we went over today, we'll do another webinar. We're going to be scheduling some other webinars. The next one is probably going to be on the New York State whistleblower law, which was recently amended and expanded and applies to private sector employers as well. That's probably one of the things. And then the Paid Sick Leave Act, the regulations have gone final. So now we have the complete picture of the New York State, Paid Sick Leave Act. So with that, does anyone have any questions? All right, I see none. Let me just say this. If you think of something, shoot me an email. You may not even want to ask it in front of everyone else. That's cool. Just shoot me an email and I'll give you the answer, assuming there is one. So with that, we'll get the other one scheduled soon, and I'll turn it back to the chamber.
Thank you very much. We will share the link to the recording with you later on. You can visit chemungchamber.org to register for upcoming webinars or find recordings of previous webinars. For anyone interested in chamber membership, please contact the chamber, info@chemungchamber.org, or call 607-734-5137. Many thanks to Michael and to everyone for joining us today. Have a great day.